All right, good morning, everyone. So welcome to today's Learning Circle session. Today's session is on wills and estates for Indigenous people. So for off-reserve and non-status. So this is part one, and Thursday will be part two, which will be on reserve. So today's conversation is in partnership with the Center for Excellence in Indigenous Health, and we'd also like to thank our partner and funder, the First Nations Health Authority, for generously funding the Learning Circle so that we're able to have these sessions. Before we begin, I just want to acknowledge the traditional lands that we are all calling in from. We're all calling in from different locations, different lands. Just want to acknowledge the traditional lands, our ancestors, the trees, the birds, the water. I am calling in from my community, from Squamish First Nation in West Vancouver. So feel free to introduce yourself in the chat and where you are calling in from. So I am filling in for Seraine this week. She wasn't able to be here. So if you don't know who I am, my name is Melanie Rivers. I'm from the Squamish Nation. My ancestral name is Tieltawit, and I am also of Scottish ancestry from the Forbes clan. And I work at the Center for Excellence in Indigenous Health. And I used to be the host of the Learning Circle several years ago. So happy to be here today. Also in the background is our production manager, Cynthia. So she'll be joining you in the chat there and answering some of your questions, putting resources into the chat for you. Just also want to acknowledge that some of the topics of the Learning Circle can be emotional. Today's topic is around wills and estates. So please make sure that you're looking after yourself. If you need to talk with an elder or a friend, a counselor, please do so. And also we will put some resources in the chat there as well. So pleased to have some guests here today to be talking about wills and estates, a very important topic. And we are going to start off our session in a good way with my cousin, Wichita, Elder Dennis Joseph, and he's going to start us off with a song, get us grounded, and then we'll be passing over the session to our guests today. So we've got Catherine and Chris, who will be sharing a presentation with you all. So I will pass it over to Wichita now.
Ostiam Hoichuch Tialtowit, my dear relative, I bring warm greetings on behalf of our elders. I am calling in from Kumkumalai, well known as Vancouver, and more specifically, I'm at BC Women and Children's Hospital, where I do work from time to time. And I'm grateful and thankful to provide a grounding and blessing for you all. And I would like to acknowledge a mutual relative. We've all heard of, I'm sure, before, Chief Dan George. A very quick story. He lost a brother and was walking the mountains, came back with this song for eventually the Coast Salish to use for blessing, for healing. And in 1992 was handed down by the George family from Tsleil-Waututh for all of us to use in the Coast Salish for this purpose. I'm grateful and thankful to share as well after this song, but I'm grateful and thankful to be sharing with you today. Oh, Osiam, Coates and Stomo, and Hot and Qualo and Stomo, just giving thanks to fellow human beings. You know, I've been giving some thought what to share here at the opening, and this is through my prayers what I've got. I would like to take a moment to acknowledge our storytellers, our artists, and I know the subject matter is wills and estates, but through our parents, grandparents, our ancestors, they've passed on their will to all of us in one way or another. And for here at home, it comes through in our ancestral names, and some would describe as our ceremonial objects. These things have been handed down through the generations, and we become the caretakers of things handed down through the generations, especially those sacred things that are used in ceremony. They come with generations of prayers, good thought, and good people. Osia, thank you.
Ichka Elder Dennis. Good morning and welcome. I'd like to begin by just thanking the UBC Learning Circle for hosting today's presentation, as well as, again, the First Nation Health Authority, and specifically Sue Bartnick, who brought us all together today. Serene, who isn't here, Cynthia, who's in the background, Melanie, and of course, Elder Dennis. We're going to be covering wills for First Nation members living off reserve today, as well as for other Indigenous individuals who may be living on reserve. The reason for this is that the legislation is different. So there will be a second presentation on Thursday that covers wills for on reserve members. I believe that that link will be shared in the chat. And I would also like to, before we get started, acknowledge with both respect and gratitude that both Chris and I are joining you from the unceded territories of the Lekwungen people, particularly the Songhees, Esquimalt, and Masonic people today. I'm thrilled to see people introducing themselves in the chat box, so thank you to everyone who has done that. Also, thank you to Melanie for mentioning that today's topics might be sensitive or emotionally triggering. Sometimes these end-of-life conversations can be very sensitive, and it also might bring up memories for you in your communities or in your families that are hard to relive. So I will start. My name is Catherine Schleicher. I'm a citizen of the Métis Nation, and I have mixed European and Mushkego Cree ancestry. I am a lawyer and program manager with Seniors First BC, which is a charitable nonprofit here in British Columbia, serving older adults with a variety of issues affecting their well-being. My particular practice area is wills and estates, and our program offers free wills, powers of attorney, and representation agreements to older adults of limited means through both established remote clinics. We have locations in Nanaimo, Prince George, Williams Lake, Chilliwack, Skidegate, Masset, and the Sunshine Coast. And we also do ad hoc clinics. So I am very, very privileged to get to spend quite a bit of time working in community, thanks to funding from the Law Foundation and Indigenous Services Canada. It's my honor to help the old ones and elders preparing the documents that we're going to be talking about today, regardless of where they live. I will pass it over to Chris.
All right, thanks so much, Catherine. Hi, everyone. My name is Chris Hesslinga. My pronouns are he, him, his. I am the director of the Law Center, which is a student-run legal or student-filled legal clinic that's operated out of downtown Victoria, as well as the Victoria Native Friendship Center, but run through the University of Victoria Faculty of Law. Just by way to kind of introduce myself and brief background, I am a settler of European descent. My mother's family lived for many generations on the lands of the Three Fires Confederacy, the Odawa, Potawatomi, and Ojibwe, also known as Southern Ontario. My father's family is from Holland, moved to Canada when he was a very small infant. And they lived in Treaty 1 territory in the heartlands of the Métis people, just outside Winnipeg, Manitoba. I grew up in the territory of the Mississauga and Anishinaabe in a small town called Campbellford in Ontario. And I've spent the last 15 years of my life living on the territory of the Musqueam, Squamish, and Tsleil-Waututh peoples in what's commonly known as Vancouver, before just recently moving to the territory of the Lekwungen, Songhees, and Esquimalt peoples here in Victoria. And I recently was given the honor of being welcomed to this land. But I was given the responsibility with that welcome to consider how I'm going to do things differently in my practice. And I take that responsibility very seriously, and I try to carry it with me every day. With those introductions, I guess I might ask if we could start the slideshow presentation. Perfect. Thanks so much, Cynthia. Have to pardon me as I ask Cynthia to change slides as we go through the presentation today. And so, yeah, as Catherine mentioned, this is just part one of a two-part presentation, and the second part is happening on Thursday. So if there's content that we were hoping to see today that wasn't covered, please sign up for Thursdays, and hopefully we'll be able to cover it on Thursday. As has already also been previously mentioned, I do want to make a specific content warning. The presentation today covers content around death and dying, as well as end-of-life planning, and includes terms such as capacity and trustee. I acknowledge that these topics can be very traumatic for some people, and that these terms have been weaponized by people with power against those without. I also want to acknowledge that it's a feature of some Western cultures to talk about death and dying openly, and that this is not shared among all cultures and belief systems and worldviews. And I therefore acknowledge how in some cultures and worldviews it's inappropriate to talk about death and dying. And I apologize if any of us offend anybody as a result of this presentation's content. It is an unfortunate reality of working in this area and educating in this area. Just to go over the agenda, we'll start off with some introductions. We'll then kind of at a high level talk about advanced planning options, which is kind of category that includes wills, as well as power of attorneys, representation agreements, and advanced directives. And then we'll also include a lot of resources and referrals at the end. Unfortunately, when it comes to kind of assisting people with their individual questions and issues when it comes to wills and estates, it's very hard for us to be able to answer questions kind of generally. And so we almost always have to tell people kind of it depends on their circumstances and that they really need to, meet with a legal service provider. There's information about how to get that meeting at the end of the slideshow presentation. Both Catherine and my organization, as well as other organizations I've worked for, are all well suited to be able to do this work. We can move to the next slide. Although a lot of the land acknowledgements have already been said, I just want to kind of repeat that I acknowledge that I'm calling in from the territory of the Lekwungen peoples, the Songhees and Esquimalt. And specifically, I want to thank them for their incredible stewardship of these lands that I've had the privilege of enjoying. I also want to make an acknowledgement about the Indigenous legal orders of the Lekwungen and Wasanich peoples, whose historical relationship to this land that I'm calling in from continues to this day. Our focus in this presentation today will be on the colonial legal system, but that is not meant in any way to detract from the legitimacy and value and importance of the Indigenous legal orders that may apply to any individual calling in today. I also wanted to kind of take a personal note about how much I deeply value and respect the Indigenous legal orders that I've had the honor and privilege of learning about through my past work when I was working at the Indigenous Community Legal Clinic in the downtown east side of Vancouver. I had the pleasure and honor of learning about a few Indigenous legal orders, always taking the passenger seat and having my clients be the drivers of those files. Unfortunately, though, my education has largely focused on the colonial legal education system. And I'm only beginning my journey to additionally learn about the Indigenous legal orders that also apply on these lands. And therefore, this presentation will focus on the colonial legal system, but I encourage all listeners to consider and engage in their Indigenous legal orders that may apply in their circumstance. So all the references I'm going to be making and I think Catherine will be making too to any kind of court processes or the law does refer to the colonial legal system. So just kind of make that general statement. Part 2, that'll be happening on Thursday, that will focus on other parts of this area of the law as well. So we've already introduced ourselves, but wanted to provide kind of a little introduction slide about who we are as well. So luckily we've already covered all this. So we'll move on to just kind of a bit of a high-level overview of the different advanced planning options that we'll be talking about today. And advanced planning options is really just a fancy way to talk about the documents that you can create to help you plan for the future, specifically a future where you're no longer where you passed away, or a future where you may no longer have the same level of capacity or cognitive decision-making or ability to think and decide things for yourself. And so there are different documents that exist and are relevant and valid at different times. While someone is alive, the documents that would apply to them could include a power of attorney document, a representation agreement document, an advanced directive document. However, once someone passes away, those documents are no longer effective and no longer apply. After someone passes away, if they have a will drafted, that's the document that applies to them. The slide also mentions that thing called trusts, and it's an even more complicated area. We won't be covering it today. And you know, for more information on that, you could try to reach out to some of the service providers, although frankly, it's an area of law that even many lawyers and law school students quickly get confused and overwhelmed in. It's kind of one of the hardest classes in law school, trust class. So unfortunately, we won't be able to cover it today. I apologize. I wish we could cover so much. You're probably going to hear me say a few times in today's presentation that this bit could be its own presentation entirely, and I apologize that we're not able to provide, you know, more comprehensive education and information. You know, this is a very large area and a complicated area, and we've done our best to kind of come up with as simple of an explanation as we can, but that sometimes means we can't include all the details we'd love to. So yeah, turning to the next slide being this term capacity. You're going to hear us refer to the term capacity probably multiple times in both today's presentation and possibly Thursdays as well. It's a very complicated concept, and so I've done my best to try to explain it here today, but I apologize if it's still hard to understand. It can be hard for those of us working in the industry and wills and estates to fully understand ourselves. So it's okay if this seems a little confusing to you. Capacity or mental capacity refers to the ability to understand and appreciate the nature and consequences of one's decision. Could also think of it as kind of someone's ability to understand what they're deciding and then what would happen as a result of that decision. It is a very complicated term. It's close to someone's ability to make a decision and understand what's going on around them, but it's a bit more complicated than that. So even that description doesn't necessarily do it. It doesn't perfectly define it. The law, though, the legal system does presume that all people have capacity unless it's shown otherwise. And that's usually required to be proven with medical evidence or sometimes a judge's decision. And so you can kind of think of it like in the criminal justice system, you're supposed to be presumed innocent until proven guilty. It's similar in the terms of capacity. You're presumed to have capacity until proven to have incapacity. The loss of mental capacity can be sudden and can vary day to day, making it very hard for people to evaluate with complete precision, and be able to evaluate, you know, from one day to the next can be difficult as well. It also exists on a spectrum. It's not just something you have one day and don't have another. It's required, though, in order to a certain level of capacity is required to create all the documents we're going to be talking about today: wills, power of attorneys, representation agreements, and advance directives. I want to take a moment, though, to recognize and note that there are, of course, issues with giving power to make decisions over other people's capacity almost exclusively in the colonial justice system to judges, lawyers, and doctors. And this is because cultural misunderstandings and legitimate fears of these professionals can and does lead to incorrect decisions regarding someone's capacity. And I recognize that it's something that can be very difficult for people to understand, but then also accept when decisions are made on their behalf about their own capacity. I have a bit of a passion for working within mental health law, and I've represented many people who are caught within the mental health system here in BC. And so I know intimately well how devastating these decisions around capacity can be. You know, to get a little personal, as a queer person, if I was born a few decades earlier, these same medical professionals could have and likely would have determined that I might lack capacity due to being queer and being true to myself. So I certainly recognize a lot of the problems and issues that exist within capacity, mental capacity determinations. But all that said, it is necessary to have capacity to draft any of the documents discussed in today's presentation. So turning to some of the documents and things that can be created to help you plan for the future. The first one we're going to talk about today is going to be wills. And it's kind of maybe one of the largest topics. We're probably just skimming the surface of, all the information we could provide to people about wills and other advanced planning options. So starting just kind of with trying to even just simply define what is a will. That can, take a lot of time in and of itself. It is essentially a written document that assigns someone to manage and distribute your assets and possessions according to the specific instructions in the will. Another way to describe it would be something in writing that picks someone to handle your things in the way you want them to handle it. The person who's assigned, or the person you pick in that document, is called an executor or a trustee. You may also see reference to a term called executrix. I've never used it in my practice. It's supposed to refer to a female executor, but frankly, I've never really used it. I think executor and trustee is an appropriate term to use, regardless of the gender expression of the individual who has that role. So yeah, you'll hear me refer to it as executor and trustee in this presentation. Wills can be changed, modified, amended, canceled, but in order to do so, the person whose will is, trying to be changed has to have a certain level of capacity again. And a will only takes effect upon someone's death. So before someone dies, whatever the will says will not apply to their situation, their assets, or their estate. Essentially, it's a document that allows people to understand what your wishes are for your possessions after you pass away. So, as I mentioned, you're going to be choosing someone, assigning someone to be your executor or trustee. You're going to be choosing this person to handle your things in the way you want them to. So it's really important to think carefully about who you want to choose. You want to choose someone you trust and who understands and respects your values, wishes, and beliefs. This is kind of a line you're going to hear actually a few times from us today, as it applies to many of the people you're going to choose in these advanced planning documents. It's common for people to choose a close friend or family member, but that's definitely not required. You want to pick someone who understands the responsibilities and will protect your assets. So think of someone who you think is really responsible. Someone kind of who you trust with your belongings, your items when you're alive. That's the same kind of person you'd want to appoint and pick as your executor or trustee, so that you can trust they'll handle your things responsibly after you passed away. You also want to pick someone who's available, who's not too busy, and who's good at record keeping. There's a lot of documentation that's required for executors and trustees. They have to keep really good records. You don't have to choose someone who lives close to you, but practically speaking, it's a good idea. You want to keep in mind all the things this person's going to have to do, right? They're going to have to handle all of your things in the way you want them to handle it. And if they live far away, that could be difficult to do. They have to close all your bank accounts, collect all your items, and catalog it all really well. So think about someone who you think would be well suited to do that. Frankly, in practice, it's not uncommon for people who've been appointed as an executor or trustee to go to a law firm or legal service provider to get help in doing this. So don't think you have to choose someone who can do this all perfectly. They have every ability to go seek help if you maybe don't know if they'd be able to do it all. There's people who can help folks who are executors and trustees as well. Although I'll admit access to that help is also difficult, as I know you're all well aware of, because that's why you're calling in for today's session. And again, just to get a little personal, for example, my parents who live in Ontario have chosen my sibling to be an executor of their estate because they live close by. Even though I'm the only lawyer in the family, frankly, I can't practice law in Ontario, and so I'd probably have to do a whole bunch of research before I'd be able to help with their estate anyway. And so it makes total practical sense for my parents to choose my brother. I'd probably be helping him anyway. Also want to make an important point here, and I'm sorry I didn't include a bullet point on it in the slides here, about choosing more than one executor or trustee. It's definitely a good idea to choose more than one. I would recommend having them be a primary, a secondary, and maybe a third backup. We might, lawyers or legal actors might call that an alternate beneficiary. So it'd be my recommendation to choose one person, but then have a few other people, a second or a third, or even a fourth as backup options if that first person isn't able to be your executor or trustee. It is possible to give more than one person equal powers and appoint joint executors or trustees, but that can lead to a lot of problems. Even people who get along perfectly well right now may get into disputes upon the passing of their loved one. Death can bring a lot of emotions into people's lives, and even people who get along very well can suddenly, turn on each other and become, quite argumentative when big stresses come into our lives, like the passing of a loved one. However, if it is your desire to have more than one person have equal say and equally be an executor or trustee, in that scenario, you'd at least want to include some way for them to resolve disputes that may arise. Again, our fancy legal terminology would be dispute resolution mechanism, but that's just a fancy way to say some way to resolve the dispute that may arise. This could be a great opportunity to incorporate a particular Indigenous legal order or practice that may apply to you or your nation. And another option would be, if you wanted to pick more than one person to have equal power, would be to maybe give one of them the final decision-making authority in the event of a disagreement. Would be another way to still have joint equal executors, trustees, but just avoid possible issues and fights. Another good practical tip is to think about the age of the people who you'd pick as a trustee or executor. If you're going to choose someone older than you, then it would be even more important to think of a secondary or third, a backup options, alternates, as picking someone older than you just increases the likelihood that they may pass away before you. And if everyone you've named as your executors, be they joint or be they alternates for each other, if they've all passed away, you need to go and write a new will, because essentially the will, at least that part of it, isn't of any use anymore. So on the next slide, I try to summarize as best as I can all the different things you really need in a will, requirements for a valid will. First one being capacity, as we talked about, is a complicated concept, but we're all presumed to have it unless it's proven otherwise. And that can be challenged, as I said before, by a court order or medical evidence. As problematic as all of that is, it's still the current state of the law. It has to be in writing, and so it's best to have that prepared by a lawyer or law school student. But I do know many people use will kits. But I do have to say that not all will kits are the same. I wish I'd had the time to kind of go and research a bunch of will kits and find, good examples and bad examples. I apologize, I didn't have the time to do that today. At least try to find a will kit that's made in Canada and ideally in your province, as each province has different rules about this stuff. And yeah, really try to avoid ones made in the States, because those are going to be even, more different than ones that maybe, made in Ontario. Even those aren't going to be necessarily very effective out here in BC. And yeah, so what I would recommend, though, frankly, it would be hard for me to ever recommend a kit. I would recommend using any of the free legal service providers that will include in the end of this presentation, and that you can also find online in some circumstance. Because yeah, the will kits are just, the same reason why it's hard for us to be able to answer any questions today. Everyone's situation is so unique and different, and the will kits aren't meant to accommodate for that. So it is, it's always my recommendation to talk to a service provider instead of trying to use a will kit. But I apologize, and I recognize that access to the legal system is not easy, it's difficult and near impossible for many folks. I've worked my entire career to try to improve on that, and I continue to and will continue to. Yeah, I still kind of have to suggest that people try whenever possible to speak to a lawyer or a legal actor. There's also this concept of an oral will, but that is not accepted by the BC colonial court system. And you may have also heard a term called a holographic will. That's just a fancy, unnecessarily complicated term for a handwritten will. So a will that's kind of just in someone's handwriting. Again, those by and large are not going to be accepted by the BC colonial court system. It is, I've read, it's possible for a court to look at a handwritten will and kind of accept it as a will. The legal terminology would be cure the deficiencies and accept it as valid. But unfortunately, I know very little about that. I've never acted in that area, I've never practiced in that area. And so I can't speak too much more about that. I apologize. It also has to be signed. So the will maker has to sign it. And it also has to be signed by 2 witnesses. Those witnesses do not have to see the content of the will. They only have to see the person signing it. So it's quite common when people are signing wills to have the witnesses be in the room, but even have a piece of paper that's covering up everything but the signage section of the paper, so that the people can't even see any of the terms of the will. It's okay for witnesses to see the terms of the will, but that's not what they're being a witness to. They're just being a witness to the signing. Hopefully that makes sense. And then who those witnesses can be, it can't be anyone who's getting something from the will. So if someone is named in the will as getting something, they can't be a witness. And that also includes, again, apologize for the legal terminology, indirect beneficiaries, or for example, children of people named in the will. Those also should not be witnesses. So kind of the easiest way to just think about it is just pick witnesses who are not in the will. And a will also has to be, just go back one more. I've got a few more things to finish on that. Thanks for that. Clear. A will that tries to provide a lot of really complicated instructions is going to be very hard for your loved ones to follow and understand. And just because it's clear to you doesn't mean it's going to be clear to the people who are trying to, follow your wishes. So that's why even if you're not going to include a legal service provider, at least try to include somebody else to kind of even just test your wishes. You know, like if these wishes, if my wishes were stated as blah, 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 would that be easy for you to understand? Because that can help you understand that, you know, although it was the instructions are clear to you, it may not be clear to other people. Complicated instructions are also likely to lead to disputes, as if it's not clear, then the people who are left trying to follow your wishes might disagree about what those wishes are, and then that can lead to court battles, which are lengthy and costly, and you know, really a bad situation for everyone to be in. You also need to make sure that the will is genuine or true, and that refers to a lack of undue influence. Again, apologize for the legal terminology. It needs to lack duress. Again, undue influence and duress are very complicated terms. I could probably spend an entire presentation just trying to explain those concepts. I'll try my best to describe undue influence as a situation when a will maker's instructions, you know, expression of what they want in the will isn't really coming from them, but coming from pressure that everyone else is putting on, other people are putting on them. And that can be especially true if the pressure that's being put on them is coming from people who want to get a benefit from the will. You know, warning signs that I often look out for are whether the instructions that are supposed to be in this will, the wishes that are supposed to be in this will, if they're all coming not from the will maker themselves, the person who the will is going to be about, but from these other people who are supposed to get something from a will. Also, if the will maker is financially or socially dependent on the people who are giving us the instructions, that can also be a warning sign and suggest undue influence. I mean, and again, duress is a very difficult thing to define. My best attempt at defining it would be to, you know, describe a situation where there's, you know, a huge amount of pressure and force being applied to somebody, demanding that they do something, essentially forcing them to do it. Now, this doesn't mean you can't try to convince your family members and parents to draft wills and attend appointments with them. You know, you should encourage everybody to have a will. But it just means that you really can't pressure them beyond just, you know, trying to convince them, just advocating that they draft a will, and really affects any influence or pressure you're trying to put on in terms of what is in the will. You know, there's, you know, it's great to try to convince people to draft wills, but you should not try to convince people what they should put in their will. That should be up to them and them alone. So yeah, that's my best attempt at trying to summarize all the very many requirements for a valid will. So we can turn to the next slide now. Again, I mean, this slide is probably not necessary for all of you who've attended today, as you're clearly interested in wills and understand their importance. But for maybe your friends or family who you're trying to convince should draft a will, you know, it certainly ensures that the wishes that you may have for your things are clear to your loved ones. You know, when someone passes away, those left trying to, you know, handle their things are often really confused and unsure. What would they want done with this? What would they want done with that? I'm not too sure. I heard them once say they wanted this. Well, I heard them once say they wanted that. It ensures all those wishes are clear because you've put it down on paper. It also allows you to choose one person you trust to carry out your wishes. If you don't have a will, you leave it up to many different people who all might want to manage your estate, be the executor or trustee. They'd all have to apply. And again, more fights could happen, and that just draws everything out and makes it worse for pretty much everyone involved. It therefore, of course, reduces conflict between your loved ones about what you would have wanted. Avoids any disagreement because it's all clear in the paper that you drafted. And it also keeps government involvement in your life to a minimum. Doesn't keep the government out of your life entirely, but it is much, the amount that the government gets involved when you don't have a will is far greater than the amount the government gets involved when you do have a will. When you don't have a will, a lot more complicated forms have to be filled out, it's much more intrusive on an individual. When someone passes away, it does create a lot of sadness and grief in the lives of the loved ones left behind, and that sadness and grief can turn to conflict and disagreement very easily. It just, based on my own practice that I've seen people who get along great and clients who say like, oh, my kids get along great, they're not going to fight over what I want. Unfortunately, I've seen those same siblings, turn on each other again, often from, grief and sadness expressing itself in different ways. And frankly, it just gives a lot of people peace of mind that the decisions they're making about their loved ones, your items, are the same decisions you would have made if you were still there. All right, I think I'll now turn it over to Catherine, who's going to talk about things that don't form part of an estate or don't go through a will.
Thanks, Chris. Yeah, so this is sometimes a bit of a confusing topic because when we think about our will creating an estate, we think about it being everything that we own, and that's a good default. But there are things that will travel outside of the estate when you pass away. In particular, those are things where you have joint ownership or where you've appointed a beneficiary. So for example, joint ownership might be with respect to a piece of property. You could have joint tenancy with, let's say, your spouse. And when one of you dies, it will automatically transfer via what's called the right of survivorship to the other joint owner or other joint owners if there's multiple ones. Similarly, there could be a joint bank account which has both the person who's passed away and another person, be that their spouse or child, and that right of survivorship will often apply as well to those. I would caution that if you're using joint bank accounts, to read the fine print of the document that the bank provides. Because if that is your sole bank account and your spouse passes away, for example, and you've been putting all of your money in as well, you may find yourself in a situation where there's a temporary hold on that. So do read the fine print, please, whenever banks are giving you documents. Similarly, life insurance policies, investment plans, pensions, all will allow you to appoint a beneficiary. If you have done this, and you can opt out of it, but if you have done this, then this is a good way to make sure that the money will transfer directly to your beneficiary, and it will travel outside of the estate. The interesting thing here is that if what you say in your will doesn't match what's on the policy or investment plan, then you might have a challenge to what happens. Technically, the policy and who you've appointed as a beneficiary would be the default, but it can create some consternation. So if you're finding yourself in any sort of situation where you've named a beneficiary, but your life has changed, perhaps you've lost somebody close to you, a spouse, a child, it's always good to review who you've appointed as the beneficiaries and make sure that it still reflects what your wishes are. If you aren't sure if you've named a beneficiary, I would encourage you to contact whatever company you have been working with, whether that's your insurance company or if you have an investment portfolio, it might be your bank. or your pension plan, just to verify if you've appointed a beneficiary. It can be worthwhile to have that transfer outside of the estate, especially if you really want it to go to one or more people in particular. It will save a lot of grief of that being potentially argued over. And if you were to die without a will, then at least that asset is covered. We go to the next slide. All right, I'm going to pass it back to Chris.
Great, thanks, Catherine. And I just wanted to note that I do apologize again that we're not able to answer questions as they're coming in. Hopefully you can appreciate it with such a large number of attendees today. It would be very difficult. As I said, there's so much for us to cover. We're struggling even just to cover all the content. But we do strongly encourage anyone with specific questions as a result of this presentation to reach out to the resources that we'll provide at the end. Like at my clinic, we can meet with you, and just the entire point of the meeting and your file with us could just be answering questions. It's totally something that we're happy to do. So yeah, please follow up with the service providers for further questions and for further help. I apologize that we're not able to do more. We wish we could. We just are limited in terms of our time and resources today. The recorded, the slides will be available, and I believe the recording will as well, but I'll leave the organizers to speak to that maybe at the end. So turning, if we can, to the clauses of a will, or the terms of a will, or the wishes that are expressed in the will, of what you want done with your things. You can include specific items to specific people, but this does get very complicated. This is probably a very common thing I see with people who we work with, wanting, for example, to give their gold ring to their granddaughter. And as simple as that may seem to include in a will, it can be necessary to really exhaustively describe that item, because although when you're drafting a will, you may only have one gold ring, hopefully you'll pass away many, many, many years later. And in that intervening time, you could actually get a whole bunch of more gold rings. It could also be something that you don't even seek out yourself. You could inherit perhaps your mother's jewelry, which includes dozens of gold rings. And then if the will just says my gold ring to my granddaughter, it'd be very difficult for those people who are trying to follow your wishes to determine which gold ring was it supposed to be. And so, you know, that's why it would have to be exhaustively described. And you'd also have to include a term, or you'd want to include a term about if that ring was lost, damaged, or destroyed. Should the granddaughter get another ring, or should maybe some estimated value of that ring? And then I also say kind of consider other possible unintended consequences. For example, if there was a tragic house fire and almost all the person's possessions were destroyed except for this gold ring, it could leave the granddaughter with really the only thing left of value in the estate. And the children, for example, might not be left with much. And, you know, you kind of want to ask your, you know, I would presume in that scenario, that probably wouldn't be the will maker's intention. So like I say, it is possible, but it's very complicated to give specific items to specific people. You know, as I've tried to make a few different points here, that it's best to make instructions simple and easy to follow as possible. A really good way to do that is to leave a certain percentage of your estate for each person you want to name. For example, 50% of my estate to my 2 children, or 50% to my spouse and 50% to my child. Again, fancy legal terminology being percentage distribution is how that's described. And that is just a really easy way to draft a will that makes it really easy to follow. One thing you could do is leave kind of an instruction sheet, which wouldn't form part of the will, but could be attached at the back of a will, which is really just a note that you can write up and say who you want to get certain things. The nice thing about doing that is because you're going to pick someone to be your trustee, an executor who you trust and believe will follow your wishes, there's reason to believe that they'll follow that little note that you have attached to the end of your will. It's not going to be legally binding. They'd have the right just to completely ignore it. But there's reason to believe they'd want to follow it as best as they can. And the nice thing is that you could just change that note however much you want to. You could, I know certainly my grandmother, before she passed away, had, most of the items in her house picked out for each one of us grandkids. That could be something that she would have written on a little sheet of paper and could have attached the will and changed as her possessions change. She would often create embroidery, and some of us would, sometimes fight over, oh, I want that one, and so she could change that at her own without having to create an entirely new will. If you did include specific items to specific people in a will and you changed your wishes in that regard, you'd have to create an entirely new will. So what I often recommend to people is creating a non-legally binding instructions sheet for people who are trying to follow your wishes. And it just helps them. Frankly, it can be very overwhelming taking an entire house full of things and trying to figure out who gets what. I think a lot of people, executors and trustees, love it when there's a nice instruction sheet about who's to get what. A bit more about will clauses or terms or wishes to be included in a will. You can include a term for maintenance and care of dependents or children, but this also gets very complicated, especially when there's a divorce or separation or parenting arrangement in place. Again, it's going to be different for each person as to whether their wishes expressed in their will about the care and maintenance of children will be followed. Essentially, whatever is happening in the family law arena is going to have also a big say in what happens to the care and maintenance or custody of children. It's not the case that if you write in the will that you want your parents to have custody, care and control of your children, that will definitely be what happens. If the other parent is appointed as a guardian and enjoying parenting time, they're definitely going to have a strong claim to maybe getting more parenting time. I mean, it's not, but even that won't be definitive. If your parents are suitable, appropriate guardians, and to have custody and care and control of children, those wishes might be followed. And it's something you can incorporate into separation agreements or divorce agreements or divorce orders from the court. You could include, and maybe something you want to consider in these scenarios, about making agreements about who's going to care for the children if one of you pass away. So it's a bit more to do with family law than really wills and estates, but it's certainly possible to include these wishes. And again, I'd say it's always great to include wishes because it helps everybody who's left try to follow your wishes know what they are. Now, there's another complicated bit about what needs to be included for children and spouses in your will. So if you're drafting a will and you have a spouse and or children, the law that applies here in BC is the Wills, Estates, and Succession Act. And that law says that a will maker's spouse and children must be, quote, adequately provided for in the will, or the court will do so on their own. Now, there's no easy and simple answer about what is adequate because it depends on every person and family's, situation. But what you can take away from this part of the Act, Section 60, for anyone who's really interested, is that it is very difficult, might even say near impossible, to completely write out or exclude a spouse or child from an estate. It's not impossible. I know that there are ways that you can not include a spouse or child if you include like descriptions as to why you're not including that spouse or child. And even the term adequate is so vague and amorphous and can change depending on the facts of the situation. It could be that if one child only gets a very small amount of an estate and the other child gets a lot more of the estate, that could still be found to be adequate if, for example, the child who only got a small amount of the estate already has a lot of money and assets in their name, and the other child who got a much larger part of the estate, a larger piece of the pie, if you will, maybe they have far fewer assets and are not as well off financially. So in that circumstance, it could easily be found to be adequate to leave very little to the child with more money and leave more to a child without. But again, it's all going to depend on circumstances of your case. And so, what I generally tell people is just, it's important to leave something for your spouse and every child. If you don't, you really open the door for people to challenge your will, to apply to the court under Section 60 of the Act, to change the will. And of course, that's, the opposite of what you're hoping when you're drafting a will. You should hopefully draft a will that's just going to be followed easily and without challenge. Right, yeah, and so including status is something you can and should also do in your will if you have it. The will maker should use the name of their children as they appear on the status cards, and you want to compare BCID to the status card for everyone you name in the document. And I know that, using names that you don't go by can be traumatic for folks. I have worked on many files where I've helped people reclaim their names that have been stolen from them as part of the violence of the colonial system. I also, as a queer person, recognize that for some trans folks, using a name that some of their assets may be registered in, being a dead name can also be incredibly problematic. But unfortunately, if you don't include all those names, it can make it very difficult to follow the wishes in the will, because not all the correct things are identified, all the different assets in any other name. But I do recognize how that can be very problematic for folks. And this last slide on wills just refers to changing a will. And so every time you draft a new will, that automatically cancels the old one. Most wills should frankly include that as an explicit term. It should spell it right out. As usually one of the first things that a will says is, I hereby cancel all my other wills. So the most recent will is the will that applies. Should review their wills if there's been a major change in their life, such as a change in marital status, once they, if they get children, if they have children, or if their assets change drastically. It's best practice to draft a new will, as I said. To avoid confusion with a codicil. A codicil is, again, a really kind of old-timey legal term, frankly, that I've never even worked with in my practice. It's kind of like this little paragraph that you would maybe add into a will. And I think they were more commonly used when everyone was using typewriters, and it would be very difficult to create a whole new document that perfectly matches your old document, but just with an additional paragraph. These days, with computers and word processors, especially if you go back to maybe the place that drafted your original will, they can probably just pull up the old will, make the change, and hit print, and then you've got a whole new will. So codicils are not something that really are used anymore. If you want to change your will, most service providers, at least all the service providers I've ever worked with, just say, well, we're going to draft a new will. It can include everything from your old will, but just with this additional change. Yeah, so I think that's everything. I know that's not everything that I could cover. It's everything that I had time to cover today. And so now I'm going to pass it over to Catherine, who's going to talk to us a bit about power of attorney documents.
Thanks, Chris. I have been trying to keep up with the questions in the chat. I do appreciate that you're keeping them general. And I just wanted to touch on the last one that I was about to type in, but we got to my point in the presentation. So what happens if you're a senior with no savings? Is there a clause to relieve executors and family of responsibility for the debts? So it is important to note that, you know, the first thing that the executor has to do is understand what your assets are and determine what debts you have and pay those off. There's some misunderstandings that go around that your debts disappear when you die, and that's not exactly the case. It only disappears if you've exhausted the estate. So I would caution people with that. But that being said, if you've named an executor or beneficiaries or family, they have no personal liability for your debts. So if you pass away and your debts exceed your assets, and those are being paid off and there's still money left owing, that's going to be a write-off for whoever you owe money to. There's orders of priority in terms of who gets paid first with the debts. But I really strongly like to warn family members, you are not responsible for your parents' debts, for example. So if you find yourself in that situation, please don't go into debt yourself paying off their debts. What you're required to do is to use the estate to pay off their debts to the point that that is exhausted. All right, so I'm going to move on to powers of attorney. Now, as Chris mentioned, powers of attorney is a document that is useful while you're alive. So at the point when you pass away, the power of attorney is null and void. It's no longer of any use, but it is a really useful document for advanced planning while you're still alive. So a power of attorney is a written document. It is legal in nature. And it selects one or more people to make your financial and some legal decisions on your behalf. It has to be in writing and it has to be signed and witnessed. Let me go to the next slide. There are different types of powers of attorney. The most common one that we use is called an enduring power of attorney. And that means typically that it's effective as soon as it's signed. But the enduring part is that it continues to be effective if you lose capacity. Now, some of you might be thinking, you know, I'm only 56. I'm not going to suffer from dementia anytime soon if it is going to happen to me. However, I do like to point out that there's a number of things that could take your capacity away. So for example, if you were to be in an unfortunate boat or car accident, you might end up in a coma and not have capacity. That might be for a brief period of time, that might be for a long period of time. But either way, tomorrow is never promised for us. And so these are important documents to still think about regardless of your age. Now, a different type of power of attorney is called springing, which means that it only becomes effective when a triggering event happens. And you can identify what that triggering event is. So that might be at a point of incapacity you want it to come into place, but it also might be that you leave town for 6 months of the year and you don't want it to come into place before you head off to Hawaii. So you can choose whether you want it to be springing or enduring, and at what point it's going to come into play. Now, when you give a power of attorney, if we can go to the next slide, you're generally giving all of the powers of you as a person with respect to your finances and some of your legal decision making to another person, to the person that you're appointing as your attorney. It's important to note that that doesn't mean that you don't have the authority to still make those financial and legal decisions on your own behalf. As long as you have capacity, you both have the ability to do that. So this can be really useful if you're not great with online banking and you just need somebody to help make sure that hydro gets paid. It can be really helpful if you have a rental property somewhere that you don't live and you have somebody that you trust that you want to manage that. There's a number of reasons that you might want to give a general power of attorney, but you can also limit it. So in the circumstance, for example, where you have a rental property elsewhere in the province and you want somebody to be managing that for you, you might limit that power of attorney to only be to do tasks with respect to managing that property. So you can limit the language so that they don't have access to every bank account that you own, or you can keep it broad. I'll also just note that when I talk about a power of attorney, people always associate the word attorney with a lawyer. This does not need to be a lawyer. This needs to be an adult. It might be your spouse, it might be a child, it might be a trusted neighbor or friend. It might be somebody in the community who supports you. What's most important is that whoever you're appointing as an attorney is somebody that you inherently trust because you are giving them a huge amount of control over your finances, and that it's somebody that's going to understand what it is that you would want. Can we go to the next slide? Banks also sometimes offer powers of attorney. We see this less and less, but again, with the caution about banks, if a bank does offer you a power of attorney, keep in mind that the bank staff or the credit union staff have drafted it. They've had their legal team draft it. They've had the benefit of their legal advice. And so it's really important that you understand what's in the document. They may not be the best person to advise you on that. You might want to speak to a manager. You might want to get independent legal advice, and you're fully entitled to do that. I do like to warn people that the language on a lot of powers of attorney are that they will revoke or cancel any prior powers of attorney. And that might be something that you want to do. However, with a bank power of attorney, it's usually specific to one account or your accounts with that bank. And so if you were to revoke your general power of attorney, which might cover a more broad scope that you wanted to keep in place, at a point of incapacity, that wouldn't be there for you if you needed to rely on it. So if you're not wanting to revoke, there is language that we usually put into the document to specifically say that we revoke all except for power of attorney given to so-and-so on X date, because we want to make sure that you have the support that you need when you need it. Can we go to the next slide? So much like what Chris was saying about executors, you're going to want to choose somebody that you trust, ideally somebody who's pretty good with record keeping and paperwork. And you want somebody who understands and respects your values, wishes, and beliefs. I know that we're talking about finances, but we do all hold different values when it comes to our finances. Some people think that it makes sense to spend $12 on a block of cheese, and other people would rather save that money for a holiday. So having somebody that maybe doesn't have the same values as you, but understands what it is that you would want is really important. You also want somebody who understands their responsibilities. There's what's called a fiduciary duty for an attorney. And so that means that they are legally obliged to act with your best interest in mind. They should be safeguarding your assets. Just because they have access to your bank account doesn't mean that they get to go to Vegas with it, even if they know in their will that they're the sole beneficiary of it. We do see abuses come out of powers of attorney, unfortunately. You know, sometimes that's from a place of malice, but sometimes it's a place of desperation as well. And so if you have somebody who's not so good with money, they may not be the person to appoint as an attorney. You can appoint multiple powers of attorney. You might get into the same standstill as with executors when there's a disagreement. So what I usually recommend to clients is that they choose a main attorney for the power of attorney, but also an alternate in case somebody is unable or unwilling to act. That might be that that person predeceases you, but it could also just be that they've come across a tough time in their life when you need them the most. So it is helpful to have an alternate in place. Can you go to the next slide? All right, I'm going to pass it back over to Chris.
Thanks so much, Catherine. All right, so next we're going to be talking about representation agreements. So these are documents, you might hear them sometimes referred to as RAs, but essentially what a representation agreement is it's a document that has to be in writing and selects one or more people to make health care decisions and personal care decisions. So we just go to the next slide about what a representation agreement is. Must be in writing and it must be signed. So it's very similar kind of to a power of attorney, but it's less about the financial and legal stuff, and it's more focused on personal care and health care decisions. So think of a power of attorney is what you deal with for kind of financial and legal stuff. And then there's another basket of stuff you have to deal with, including personal and health care. So this kind of deals with that other basket of stuff to deal with. Also similar to power of attorney, you can name more than one to be joint, but as Catherine said, it's best to have alternates or have a primary and then a backup and perhaps even a third backup. And for, frankly, all of these documents, representation agreements, powers of attorney, and wills, only the person who's giving up, say, power under the power of attorney, or the will maker, or here the person who's appointing someone as their representative, they're the only ones who should be giving instructions for these documents. It's quite common for adult children to try to get a lot of these documents done for their parents, maybe their aging parents. But in those scenarios, it's only the older parents who can give the instructions. So as I said before, it's great to encourage folks to get this stuff, but they're the ones who have to give these instructions. Turning to the next slide about the different types, there are two different types. There's a Section 9 and a Section 7. They're referred to as that's just the section of the law that they come from. So the Representation Agreement Act is the law that applies to these documents. And Section 9 talks about representation agreements that really focus only on healthcare decisions and can include all major and minor healthcare decisions. So a lot of power can be given under Section 9 representation agreements in regards to healthcare only. Can also include the day-to-day decisions regarding healthcare. Often they're needed for a senior housing facility. A lot of the senior housing facilities will require these representation agreements. And the representative, the person you choose and appoint in this document, can request or refuse certain treatments. And this document is often combined with an enduring power of attorney because it endures beyond your incapacity. Turning to the next type, the Section 7 representation agreements. These deal with slightly less serious or smaller decisions but they include not only healthcare, but also some limited financial decisions. So just think of it as like lower level decisions. It's kind of nice. I always remember them as, since 7 is lower than 9 on the numeric scale, it helps me remember that gives you slightly lower levels of power to make decisions. So it'd be just routine management of financial affairs, like day-to-day management of bank accounts, routine management of legal affairs, and routine management of healthcare decisions. This would, if you only had a Section 7 representation agreement, it wouldn't likely be useful in order to move someone. Say you have a Section 7 for your parent, it probably wouldn't be effective in order to move that parent into a long-term care or assisted living facility without that individual's agreement. And then just turning to kind of compare the two, as I said, Section 9 and Section 7 are the two terms that we use. Section 9 is a higher number and a higher level of decision-making ability. But Section 9 representation agreements do not include the power to make any financial decisions, but they can make much more serious decisions overall. Section 7 representation agreement includes some financial decisions, but only the simple, routine, smaller, lower ones. And therefore, actually, are kind of connected to that different level of power that's given in them, a lower level of capacity is required for a Section 7 representation agreement. And so, as I mentioned, capacity exists on a spectrum, and it can change. And so, if someone might be losing their capacity, they may not have enough capacity to complete a Section 9, but they might still have enough capacity to complete a Section 7. This could also be an opportunity to include use of traditional medicines, elders or healers at end-of-life ceremonies. You can provide specific instructions on traditional ceremonies, such as smudging, sage burning, and spiritual bathing. Bit of a caveat here, though, that sometimes for health and safety policy reasons, some facilities, and it's up to those facilities, may not be able to accommodate all of those wishes. For example, burning sage in an enclosed space may be an issue for those with severe asthma, but again, that's all going to depend on each individual person's case. A place that wants to try to deny would have to be able to prove. It can't just be that they think they have someone who might have severe asthma. It'd have to be, clear proof of the inability to accommodate. But that gets into human rights law, which could be its very own presentation again. Apologize, we're not able to cover everything we wish we could cover. All right, next. Oh, sorry, just going back one more slide. I didn't get to yet talk about who to choose as representative, but it's a lot of the same stuff we've talked about in terms of same considerations you're making when you're thinking about who to choose as your executor in a will or who to choose as your attorney in a power of attorney document. You want to choose someone who you trust, who understands and respects your values, wishes, and beliefs. A lot of these choices are even more personal, sort of, than the financial stuff that would be included in a power of attorney document. So this is where maybe someone who really aligns with your values and beliefs, or understands them at least, is even more important. And you trust will follow them too. Also, maybe, even more important to think of someone who's going to be available locally to assist you. Those considerations are maybe less important with power of attorney documents and wills, but much more important with the representative who you're choosing. And who can assist in making the personal and healthcare decisions on your behalf. Again, the comments about naming more than one person, I'll repeat here that my advice is to name them as backups, one, then the other, then the alter, or using alternate representatives. And that it's only the person who's appointing a representative who can give those instructions. If you're going to include more than one person with equal power, best to include things to help them solve disputes that might arise. And I also want to take a note here that I know I've kind of said this thing about more than one person making a decision and how the problems that can come from that. I want to recognize that that's very much coming from my like Western European culture that I've been raised in. I try to approach all my work with cultural humility and realizing that in some other cultures, joint community-driven decision making is deemed more important and is encouraged and supported more. And so it is just my view that I share this view about choosing one individual. In your culture and in your community, it might be completely appropriate and totally fine to name more than one person with equal power. You know, it is always, when I work with clients, it's always their ship that I'm just helping them sail. They're always in the driver's seat. I'm just in the passenger seat, trying to help them with directions and point out different ways to go. I always make sure that my clients are in the driver's seat and they get the final decision about what to do with all this stuff. So feel free to disregard any of my suggestions in this presentation, because they all just come from my worldview. I think that's everything I wanted to say about representation agreements. I'll turn it back over to Catherine to tell us a bit about the last document we're going to talk about, advanced directives, and then we're going to hopefully get some time for some summaries, but I know we're near the end, so try to be as quick as we can.
Thanks, Chris. So the advanced directive is a good segue coming from the representation agreement, because I think that there's often a lot of confusion between the two of them. So often when I meet with clients, they will say, I don't need a representation agreement, I have an advanced directive, or they will say, I want a do not resuscitate. So I think it's helpful to touch on these documents, even though my program and Chris's program, it's not a service that our team usually provides. So if we can go to the next slide. Thank you. So an advanced directive is any form of written instructions that give or refuse consent to certain healthcare treatments. This sounds probably pretty familiar, but it's usually very, very specific. Now, I don't love advanced directives. It's impossible to take all considerations into effect. Whereas, you never know what your health treatments might be down the road from now. So it is helpful, I think, to have a representation agreement in place, because then you have a person who's making that decision that aligns with your wishes. But if there's something really specific that you don't want, you can certainly include that in your representation agreement. It could be a broad representation agreement that just covers everything, but you can also put in specific things, whether that's I don't want blood transfusions, or I want a dying with dignity clause. Those sorts of things can be included. Now, a do not resuscitate is a type of advanced directive. It's one that you're going to want to do with a doctor. So don't call a lawyer about it. It's better for you to go through that process with your doctor. But again, this comes down to really specific treatments. And so if there's something that you don't want, whether that's your personal belief or something that traditionally isn't acceptable, or something that religiously you feel strongly about, for example, blood transfusions, this can be a really useful way to convey that. Now, having an advanced directive doesn't invalidate having a representation agreement, and vice versa. The representation agreement actually requires that your wishes are respected. And so by having done an advanced directive, that's an expression of your wishes. And so it's expected that they will work together. But technically there is a legal priority. So the representation agreement is higher than the advanced directive if there is something that misaligns. Now, for the advanced directives, like I said, it's not a replacement for a representation agreement. Appointing somebody to make those decisions that may be unforeseeable at a point currently, but down the road will come to fruition, is really, really helpful. And having somebody that can also cover those personal care decisions for you about where you're going to live and and what you're going to eat and make sure that your wishes are upheld is absolutely valuable and something that often I think gets overlooked. So I will pass it back to Chris to wrap us up.
Great, thanks so much, Catherine. So I'll just briefly kind of just talk about our last slides here. If we could just more to the process of drafting these advanced planning documents. I just wanted to kind of help people get a image in their mind about kind of what it's going to be like to go through this process. Try to make an appointment with one of these service providers, such as the Law Center, LSLAP, or the Law Students Legal Advice Program, or Seniors First, all great ones. Give instructions and work with your service provider. Review drafts they send you, and ask questions if you don't understand something. That is what I really want to drive home to people. These are your documents. This is your life. Don't, accept when people give you one explanation that doesn't make sense to you. Ask for another. We as legal service providers can be really bad at recognizing when our explanations aren't easy to understand. And so I really encourage people to ask questions if they don't understand. Executing documents, just a fancy way to say sign them. And then what I failed to include here is importance of safely securing your documents, hopefully someplace that's waterproof and fireproof. And then registering your documents is an option. It's not necessary. For wills, you can register the location of the will, not the will itself. So it's a bit of a misnomer when they say wills registry. So you're really just registering the location. And then the next slide, I just try to summarize things as best as I can. With wills, you're talking about a document that tells people what you want done with your stuff. Power of attorney, again, is a document that picks someone to handle your legal and financial matters. A representation agreement picks someone to handle your personal and healthcare matters. An advanced directive focuses just on specific healthcare wishes. And yeah, then the resources are on the final slides. There are more. Those were just some of the ones. But when reaching out to my organization at the Law Center, contacting us by telephone is the only way to make an appointment. We also, though, are currently doing intakes at the Victoria Native Friendship Center. I'll let Catherine talk about best way to access her services as well.
Yeah, so Seniors First offers a number of programs, not just the one that I am managing. So again, it covers off a variety of issues that affect older adults. The Law Center also covers off a variety of issues and not just wills and estates. So these are valuable resources for the people who are interested in today's topic, but it also might be something that you want to refer someone that you care about to for a different topic. So keep in mind that even though our topic is narrow today, there are other services available through both of these. The best way to contact Seniors First is through our phone numbers. There's a Vancouver number, but also a toll-free number here on the slide. It's also up on our website. So it is available for people 45 and older if you identify as Indigenous, and 55 and older for those who don't. You may have loved ones who do not. And yeah, the telephone number is for our Seniors Abuse and Information line. That doesn't mean that you're necessarily going through any sort of abuse, but our intake workers will chat with you or somebody that you refer to determine what it is that they're needing, wanting, what the appropriate referrals are, and that's how you access our legal programs as well. You go to the next slide.
The Law Students Legal Advice Program, LSLAP, is an organization I used to work for. It's run by law school students, so kind of be patient. They tend to take a bit longer to do things, but they also don't help with signing of documents, so that's one limit on theirs. And then through the lawyer referral service, it's a bit of a two-stage process with the lawyer referral service, which I appreciate can be a little annoying, where you have to contact the lawyer referral service. They'll give you the name and contact information for a lawyer. You then can contact that lawyer and get, again, only 15 minutes of free help, which again is not enough, I recognize, but you can use that service over and over and over and over again and get the names of a lot of different lawyers and go seek out whatever lawyer Sorry for running over time, everyone.
Wojcika, thank you, Chris and Catherine, so much for this really valuable information. Really appreciate the care in which you provided the information and understanding the sensitivity of the information. Lots of thank yous in the chat about how valuable these resources are, and really appreciate also the complexity of the information and the legalities of the information that you shared today, and doing your best to share what you can within the time frame today. I also really appreciate the acknowledgement of our traditional laws, our traditional tiach, and acknowledging that we're working within a colonial system when we're talking about wills and estates. So Wojcika for that. So I want to pass it over to Wichita to close this off in a good way, and then I'll have a few little closing announcements after that.
Ostiam Wojciech, my dear Sese, my dear relative, I'm grateful and thankful as well to those providing all of the teachings, and like you, my dear relative, I reflect on our teachings and how from time to time they do have a little bit of an intersection. When I listen to the representative agreement, I reflect on some of the old teachings our elders taught us about ceremony. And when our elders get to a point where they can't make a ceremony, weddings, namings, etc., they'll send somebody to be their eyes and ears, to go to a ceremony and report back to them what they saw, what they heard, what they felt. So I'm grateful and thankful, and cannot underscore, given the work I've done in the past, supporting families in times of loss, to do a will. It's inspiring me to do my will, and I'm getting to that age where I need to take care of it. My hands are up to you. I'm grateful and thankful for your work. I know we're running in a bit of an overtime. Invite you, as I move into the language, to share in your own way reflection about the teachings, the blessings for you all. Hosiam, Hoichuk Hanek Chasiam, and Haas and Squalwin, Chish O Homeo, Hoichuk Skachastomo, and Haas and Man, Tuma Kutsikutsnachum, and Sese, just giving thanks to the Creator, all of our ancestors who've gone before us. We're grateful and thankful for the sharing and teaching here today. Any healing prayers in our heart, Creator, hear them, especially those of our ancestors and our children. Tuma Kutsikutsnachum. Take care, everybody.
Wojcika, Wichita.
Yeah.
Appreciate the closing words. Ground us out after this very important conversation. So just want to highlight some upcoming learning circles. So importantly, there's lots of questions and people wanting more information. So part 2 of this presentation will be on Thursday, though that session will be focused on reserve wills and estates. And then you can see some of the other upcoming Learning Circle webinars, which you can sign up for on our website. They're all free. And also be sure to sign up for our newsletter as well. So thank you all for joining today, and thank you for all the beautiful comments and questions in the chat as well. So Wojcika, everyone, wishing you all a good rest of the day and week.